This is Law Bites, a podcast with Michael Geist.
Another topic on our agenda was online safety and Bill C-63, which is in the federal parliament now as we speak. Hate crimes and hate speech are on the rise across the country. The scope of the challenge before us is immense, and all levels of government have a fundamental role to play in keeping people, particularly kids, safe online. At the same time, we want to ensure that all people in Canada can exercise their fundamental expressive rights free from threats of violence and hatred. We may not always agree on the mechanisms, but we all agree that everyone in Canada deserves to feel safe and to actually be safe. That is why, to ensure that we have the best bill possible, we are open to amendments to this bill, including those proposed by provincial and territorial partners. We're trying to get this bill to committee as soon as possible so that we can hear from experts from across the country and assess any amendments that are necessary to improve this bill.
The Online Harms Act, or Bill C-63, was introduced last February after years of false starts, public consultations, and contentious debates. Months later, the bill appears to be stalled in the House of Commons and has yet to make it to committee for further study. Some view that as a win, given their criticism of the bill, though others who have waited for years for action against online harms are beginning to fear that the parliamentary clock is working against them. Emily Laidlaw, the Canada Research Chair in Cybersecurity at the University of Calgary, and Taylor Owen, the Beaverbrook Chair in Media, Ethics and Communications at the Max Bell School of Public Policy at McGill University, have both been actively engaged on this issue for years, including with their participation on the government's expert advisory group. They joined me on the podcast to discuss where things stand on Bill 63 and the steps they recommend to get the bill back on track for study and debate. Emily and Taylor, welcome to the podcast.
Thanks for having us.
Yeah, thanks for having us.
Okay, it's great to have you both back on the podcast. Both of you have been deeply involved in the development of Canada's online harms legislation, both initially through your work on the expert advisory group and then, of course, subsequent analysis of Bill C-63 once it was tabled earlier this year. The bill seems stuck in the House. It still hasn't gone to committee. It's still sitting at second reading. And with an election looming sometime, I suppose, in the next year, I think some of the doubts about its future have increased. Now, I've covered the substance of the bill in a series of podcast episodes in the spring. I think we've all done quite a number of different panels on it. Emily and I were in one together several months ago. And so there's been a lot written about the bill. You've written most recently about how we might try to save the bill given some of the challenges that we're facing. Now, before we get there, I want to unpack a bit some of your suggestions. Can you describe, having participated in a lot of the discussions after the bill was introduced, what has been some of the public and expert response to the bill? There's been some support, some criticism, and I guess some questions as to whether or not this is a bill worth saving. So I'd welcome your thoughts on where you see the expert and public response to this legislation. Why don't we start with you, Emily?
Yeah, thanks. It's I would say that a lot of the public reaction has tended to conflate all the parts of the bill into one criticism. So I'll often see a headline or a comment from a stakeholder that it's censorship, that it's got these problems, that we need to go back to the drafting board. And then when we look a little bit closer, the criticisms are about the Criminal Code provisions and the Canadian Human Rights Act provisions, and not about Part 1. When I have conversations about Part 1 of the bill, the social media regulation, it seems broadly supportive, that it's sketched appropriately, but that amendments are needed. But it's detailed amendments, right? It's how do you tweak this? How do we make sure this is clear? The broad structure itself is I think welcome. The one debate about Part 1 that I think might happen is about the scope of it, what should be included or not. There seems to be some desire to just focus on kids' safety, while others want it even broader than it is right now.
Okay, I think that's true. And certainly the kids' safety stuff, a point of emphasis for Michelle Rempel-Garner's private members bill. Perhaps we can come to that in a moment. Taylor, what are some of the things that you've been hearing about?
Yeah, I mean, I think in general, when in the public is broadly supportive of, at a principle level, of regulating social media to minimize clear harms that they experience. And we still see that throughout the debate over this bill. I mean, the survey results are pretty high. The question is when you get into the details of what you want the government to do, right? So we have to separate in the public mind the desire for something here and differing views on their knowledge of elements of the bill. In terms of the kind of political and expert response, I mean, I think I broadly see three categories. The one somewhat predictable one was kind of the conservative dismissal of the entire thing in whole as an effort from the government to censor the internet writ large, right? And I think that just utter dismissal of the model was somewhat predictable because we saw it on previous bills, and kind of is unfortunate because I think it deludes the quality of the debate about the specifics of the bill. So I think that's one category that we've seen. Another would be pretty reasonable and sophisticated and detailed critique of the inclusion of sections 2 and 3, the criminal code and human rights amendments. And I think that has actually been there's been a rhetorical debate that's included in that first category, but there's also been a very substantive conversation about, one, should both of those things be done at all? And two, if they should be done, should they be done in the context of a digital governance bill? Or should they be treated separately outside of that? Because clearly they go beyond just digital hate speech or digital hate discrimination in the Human Rights Case Act. So like that's been a healthy conversation. And although one that's been distracting from passing the core of the bill, which, as Emily said, is part 1 and 4, which is the regulatory model, which makes up 90+% of the bill. And then I think a third category, and just leave it here, is that there's been some very reasonable concerns about that part 1 and 4. And I think that's the debate we should be having. And that's the one I relish having and think the bill could be improved. And it's the one we should have been having from the day they tabled it, because that should have been, in my view, what was tabled. And we could then having 2 of those 3 debates, not all 3 of them at once, which has been really tricky.
Yeah, no, it's certainly that conflation of all of these issues, I think, has really represented a challenge in terms of having the kind of robust debate that you mentioned. What's been happening from a legislative perspective? I mentioned that it doesn't seem to be moving quickly in the House. Can you talk a little bit about how far it's gotten? What kind of debate have we had, if any, so far in the House of Commons?
It's I think part of the problem is they waited way too long to table this bill. And then once they tabled it, they didn't move it fast enough through the House. So now, with the limited time frame of a government, I mean, who knows if it's weeks or months, but we're now stuck in a procedural complication / roadblock in the House, which is stopping it from getting to the Senate, or sorry, to the committee. And in order to get out of the House and into committee, the government needs either the Bloc or the NDP to agree to a time allocation motion. And both have refused to do so at this stage. So without that, it's stuck in the House. After that, it will go to committee, and we can talk about what that might look like at committee. And then it goes to the Senate, right? So sure. It's hard to imagine this happening in a best case scenario in under 6 months from now. So really, we're up against a ticking kind of time bomb of the government's survival. This was all predictable, right? Like this is why Emily and I wrote a year ago that this thing should have been tabled already. It was already late to be tabled.
And I remember back when we were on the expert committees, you're thinking that would have been May-ish 2022. Our advice to the government was, you've got to get going. You have to write this quickly so that it is passed quickly, that it's studied thoroughly and passed quickly, because it needs time to be entrenched before the next election. I mean, the best we can hope for is this goes to committee and is passed before the next election, but even that is tight at this stage. But without anything entrenched, it could be unraveled quite quickly anyway.
Okay, fair point. And so timing is unquestionably tight.
Mhm.
You've provided some recommendations. If there is some movement about how this might get ahead of an election call in terms of getting through some of that legislative process, you start with prioritizing the bill. Aside, I suppose, from getting past the procedural blocks, and
Mhm.
with the bloc now saying that they're going to try to find ways to bring down the government, it seems that there are not a lot of dance partners to do that. But assuming they can overcome that, what do you see? What would involve prioritizing this legislation so that you can get it done within that, say, 6-month time frame if the government lasts that long?
I mean,
I
I'm not
know.
sure the procedural um and the substantive are necessarily separate. I think at this stage, a willingness to amend substantively and potentially divide the bill are probably prerequisites for getting the support of either the NDP or the Bloc to get over the procedural hurdle. So these things might be one in the same at this stage. We might just be at this roadblock where, um, and I mean, it sounds like there's willingness on the government side to do that. Um, it also seems like the NDP is dragging their feet on that, and which is a bit of a mystery to me because they have been supporting, in principle, the structure of this bill, the whole bill, in fact, from very early stages. And to now at this stage be putting up this block, I'm not exactly sure what's going on there. But I would imagine from their perspective, openness and commitment even to amendments are going to be part of them helping to get this into committee.
Well, I think that some political shenanigans at this stage has gotten in the way of a focus on what's the real issue here, right? This is an important bill to be studying in substance, and that's not happening. I think that my understanding is the same as Taylor, that I think that there's some willingness by the government to split the bill, which I think is the first step. But I think that the government should come out and say that. So if they really want this to get to committee, that should be communicated now, that there's a willingness to entertain amendments, that they are hearing from the public and would split the bill. And then we can go forward with that study. I think that the Conservative Party was successful in I think in politicizing and polarizing the debate on this issue. So I suspect that even the NDP, for example, are tentative because this is such a hot button issue now. And the whole bill has this taint to it that it's a censorship bill. And I think if we want to get past that, there needs to be that communication. They're going to split it right now.
There's a potential case that certain NDP caucus members are concerned about switchers from the NDP to the Conservatives, and that those people are concerned about the speech elements of the bill. If that's the case, it seems to me it would be a win for them to have succeeded in splitting the bill and removing those potential speech issues from the core of the bill itself.
Emily, just to follow up on the when for the split, because I mean, the rumors are that there is at least a willingness to do that now. Is that something that they do before you even get to committee in your view? You just sort of say, hey, listen, we're taking this off the table for the purposes of the study. And if so, what does the committee hearings look like? How much time, how many meetings, what kind of detail do you think we need to look after that part one in particular, that as was mentioned, still has issues that are worthy of further investigation and debate?
Yeah, so I think the government should state now that they're willing to split the bill, because I think that it takes a bit of the wind out of the claims that there's so many problems with the bill, and enables it to go to committee to study. But I don't think that they'll be able to split it until they get to that committee stage. I do think that they need to fast track part one at this stage, just given the risks that an election could be called any day. But it's a bit of a dance because part one needs thorough study. One of the problems with so much focus on the other parts is that there hasn't been enough public discussion and understanding of part one to be able to give it the scrutiny that it needs, unless you're kind of law nerds like us, right? So So how many is needed? I don't know. And I'm curious what you think, Michael, if you
Mm.
think that, what would be an appropriate length of time, an appropriate number of committee meetings to be able to thoroughly address part one, hear amendments, but also deal with this quickly.
Yeah. I mean, certainly from my perspective, I guess I'm a bit jaded by the experience that I saw, especially with Bill
Mm.
C-18, the news bill, and to a lesser extent C-11, where I thought the Senate did a good job of demonstrating just how shallow the committee hearings were in the House. And I do have some concern that we could see that kind of approach repeat here, where you get a panel or two of academics, you get a few
Mm.
advocacy groups from a couple of the main places, you get the minister, and then you say, hey,
Mm.
we've done our job here. And especially when you look at the number of different issues and harms that are on the table, I think it's important to hear from groups that come out of many of those different harms, so that you know have an
Mm.
understanding as to whether or not the kind of proposed approaches are going to actually address some of the core harms. I think we need groups who may be able to speak to other issues that aren't in the legislation right now, and perhaps make the
Mm.
case that there are things that ought to be included. We need
Yeah.
certainly people who've got some expertise on the governance side to take a look at what this administration is going to look like and some of the issues that arise out of that. Surely need to hear from the platforms. You need to hear from expression groups. Uh, I think it's pretty extensive, and failure to do that in some ways sets this up just to punt the same kind of debates over to the Senate, which puts you potentially in another box where they conduct more extensive hearings and perhaps send it
Yeah.
back to the House. And then when you're faced with tough timelines, that's not very helpful at
I
all.
think that's a
So
super important point, right?
Yeah.
That doing this properly in the House potentially ends up streamlining it in the Senate. And that's a far more efficient way of doing it, it seems to me. But there's an added thing here, which is length, number of people appearing and scope of the people appearing, and the length and the number of hearings, and an openness to amendments. So it's one thing to hear people, it's another thing to listen to them and take their, and I think we need both here, right? And it's a balance of the two. And arguably, if you're open to listening to them, you could truncate the time period a little bit, because a lot of people have quite established views on this, right? I think we could get people's suggestions, and we actually know what a lot of them are already, into the record quite efficiently. What it needs is the government to also build a new package out of them that reflects the scope of that concern. But all of this also speaks to whether you can also have a fulsome debate and discussion of the two, of sections 2 and 3 and the criminal code and the human rights tribunal amendments. And I mean, Emily, I don't want to speak for Emily here, but generally our views on this have, I think, been fairly aligned, which is there actually is an important debate about both of those. Now, they've been uniformly dismissed by some in the public and by some political actors for sure. But there's a lot of people who support both of those things, particularly Section 13. I mean, that's been a debate for 20 years in this country. And there's some really nuanced views and a whole host of different civil society and legal groups on it. And it would be wonderful to have a conversation about that, I think. But maybe we just don't have time. And maybe the cost is we have to move that substantive debate to another time so that we can have one on part one.
Well, yeah,
no,
I'm tending to think that the substantive difference between those two is that for part one, after so much consultation, the idea of the regulation itself seems to be relatively widely accepted. It's the how. And the how is where we can get into,
Yeah.
I mean, all kinds of key detail. I mean, even down to tiny things like there's an information sharing provision about what regulators can share what. And I looked at it thinking, this is absurd that you would set up a digital safety commission that can't share information, receive information from the privacy commissioner, given the crossover with these data-driven types of businesses. So that's the tiny work that we need to do. But yeah, parts 2 and 3, there is a question about the legitimacy of those provisions at all. And so I think that is a whole other beast and needs to be, I mean, if you do debate one and keep going with, Bill 1 of C-63, fine, and then deal with the others differently. And that needs to be a much longer consultation.
Yeah, no, I think that's right. And certainly if it is everything, and if they don't follow the advice we heard earlier of taking 2 and 3 off the table, off the top, I mean, then you're looking at far more extensive hearings, even than hearings that I think still need quite a bit. To Taylor's point about reading into the record or identifying some of the concerns, there has to be a willingness to actually bring some of those on board. And we've seen the government that at times has been reluctant, and this is true for seemingly all governments, have a reluctance to
Yeah.
make changes once they get to committee. Of course, taking out 2 and 3 would be the signal to say we didn't get it perfect. We're actually taking this off the board, and we're also open to making real changes. Our priority is passing the bill, not passing this particular bill. Uh,
Yeah.
but that would mean being willing to take potential concerns and proposed amendments on board,
Or
which
worse, here, I have one other scenario here. Let's say that they don't split the bill and they do fast track and shorten the study of it at committee. Perhaps it's slowed down and held up at Senate, but let's say it passes. Then it undermines the entire legitimacy of the online harms bill.
And further
And the
politicizes it.
legitimacy of the regulator, right? It would taint the whole thing.
Yeah, no, I certainly think that's true. One way to address it would be to address some of the kinds of concerns that exist, especially in part one. You've identified in your piece a bunch of different issues that you think ought to be top of mind. Can you describe what some of those might be if we get to the point where we're starting to look at how we might improve, especially the part one of this bill?
I think the number one amendment that I'd like to see is that the duty to act responsibly isn't just to mitigate risks of harm in those 7 categories, but also to protect fundamental rights, in particular freedom of expression and privacy. Back when we had all advised the government on a bill, I mean, there was pretty much consensus that that the risks of harm weren't just in the areas of, say, hate speech or child protection, but also risk to free expression and privacy. And you needed those twin duties on companies. That is not in the final bill, and that needs to be added in. And that is in, for example, Europe's Digital Services Act. It's embedded even in the UK's Online Safety Act. My understanding is that I think some of the legal advice has been the government can't do that. I mean, it's an interesting legal problem, and I think that's wrong. I think that there is definitely scope for government to require companies balance these fundamental rights. It's just that they can't require companies to do something that would in and of themselves infringe the free expression rights of the companies. But I want to see that in the final version.
Okay, Taylor, you have some priorities out there?
Yeah, I mean, I think there's always a balance in this kind of legislation between what gets written into the legislation and what is left to, in this case, a regulator to determine. And there's a balance there because things that are written into legislation get locked in. And when we're dealing with some of these issues related to digital technology, they're evolving so rapidly that we can't always know what the threat or the harm is going to be, or even the technology is going to be. And we don't want to lock them into legislation. And so I think we see a number of places where they've erred on the side of ambiguity and leaving it to the regulator. And I understand the reason for that. And in a different moment, that might have been the wise choice. But in a political moment where people are rightly or wrongly nervous about the powers being entrenched in this regulator, I think it might benefit from erring on the other side, which is more specificity in the legislation. So I can think of a number of places in the bill where that might be the case. On the duty to protect kids, for example. It's an entire duty. It's one of 3 duties in part 1, and it is the total of 2 sentences. Now, essentially, it just says you need to do an age-appropriate design. You, regulator, need to do an age-appropriate design code that's suitable for the moment and for Canada. I think it's probably worth putting a little meat on that, on what could be in an age-appropriate design code, what has been in other jurisdictions, just so people have a better, clear sense of what this will mean and what protections will be enforced, which I think is important for people to know. I think that's probably the case with some of the powers of the regulator, if you've pointed out, Michael, that we're entrusting a huge amount of potential power to a new regulatory body. in an area of people's lives that touches on their speech and their free association. And I think that's probably worth spelling out in slight more detail what we mean by those powers, what they could entail, where their limits are. The flip side of that is I think you need the regulator to be powerful because we're dealing with very big, powerful companies who have a huge impact on our society. But I think we should probably err on the side of detailing them more. So I think it's places like that where added specificity might ultimately limit the regulator in what they can do and their flexibility, but it'll add clarity for the public on what this thing actually is and isn't.
I think that the other place where they made that decision to leave it to the regulator, but could be developed further is algorithmic accountability. When I read the bill, the duty to act responsibility to mitigate the risks of exposure to harmful content would include the underlying algorithmic systems that push that content. And same for the duty to protect kids includes the design of the systems. But it's not clear enough. I think that we all know that the algorithmic systems are core to driving forward that content. And so I think that needs to be spelled out in more detail, precisely that the duty on these platforms to address that particular issue. And that still leaves a huge amount of scope for a regulator to develop codes of practice that are, in the moment and reflective of the tech and the harm at the time.
Okay. Now you spoke about some of Taylor, you mentioned the Digital Safety Commissioner, that kind of the enforcement piece. Your piece that talked about how to try to get this moving talked about speeding up the process to create this enforcement structure. What did you have in mind in terms of how you might go about doing that?
The reason we think it's needed are twofold. One, it will be very easy to roll back a legislation if there is not an established entity of some sort fairly soon after the law passes. And it will take a significant amount of time to design, build, and align with other international regulators this model. And some of that pre-work we think could be done before legislation is passed. And the model for this is what Ofcom did in the UK. So before the Online Safety Act in the UK passed, Ofcom had hired 300 people to begin designing how they would comply with the legislation and enforce the legislation. And in particular, how they would articulate the codes of practice that were embedded in the legislation, which we also have. And for Canada, it's the risk mitigation plan, but it's essentially the same as the risk mitigations in the Digital Services Act or the codes of practice in the UK. And this is what it's kind of in my view, one of the most critical pieces of this whole model, which is if a platform finds a risk via their risk assessments, they are then obligated to do a set of things to mitigate that risk. And that is these codes of practice. And it's going to take some time to develop them because in Canada, this is codes of practice on 7 different types of content. And they will have to do different things to mitigate the risk of different types of those content, affecting different segments of society in different ways. And some of that pre-work could be done in collaboration with the international regulators that are already a bit ahead of us in doing that. So we just think some of that could be at least started in the expectation that this passes at some point.
Just staying with that for a moment, I mentioned Michelle Rempel-Garner's private members bill, which has emerged as the Conservatives' response to C63. I'm not sure that was the initial intent. It wasn't clear that it was a party thing, but it seems to be now, at least based on some of the debate that we've seen take place in the House.
That it was launched on her Substack might be an indication that it was initially her initiative and then became a party one. But
I think that's probably a fair supposition for sure. Now, there is a bit more meat on the bones, to use your phrase, on some of the kinds of issues. She actually does provide a greater amount of specificity, but really one of the key differences is that there is no digital safety commissioner, relying instead on existing enforcement mechanisms. What are your thoughts on that approach? Do you think we can address these issues using what we already have, or is it essential to have some kind of body to deal with this sort of stuff? And if not the Digital Safety Commissioner, then some other new body or someone has to be in charge of all of this stuff or lead the way.
I think we need a new body. And, back in the day, I had looked at this like years ago when I was in the UK. And even then, I'd said, whatever you do, not Ofcom, because I didn't think it should be built out of broadcasting regulator. And in particular, in the Canadian context, I was surprised that the proposal from Michelle Rumpel-Garner was for adding this to the pile of things that the CRTC should oversee, given the pushback about Bill C11, C18. So I think it'll just be too bloated of a regulator. I also think fundamentally broadcasting and telecoms regulation isn't the same as the intricate tech policy and human rights issues we're talking about here in platform regulation. So no one wants to build a new regulator, but we need to. The e-safety commissioner was, their own body, but built out using the resources of their broadcasting regulator. I do understand that was still difficult because the knowledge and understanding was still broadcasting based. So as much as we don't like it, it is time for a new regulator, and we don't question the existence of a privacy commissioner or a competition bureau at this stage. I think this has been a long time coming. So I also think there is such a key element to this about research and education that is kind of core to the Digital Safety Commission and office that could be lost if it's just pushed through the existing model with the CRTC.
That e-safety commissioner being, of course, the Australian approach. Taylor, you have the same view. We need some kind of structure, and this is as good as any if we get some of the specifics right.
I think there's a reasonable argument, and some made it, that this should be given to the CRTC. I also find it odd that the party that's been so against adding more capacity to the CRTC because of its supposed bloat and incapacity, which may be true, wants to add more in terms of digital regulation into there. But the other piece of it that I think deserves some focus is how much this places on the judicial system. And I think there's a almost philosophic challenge here that the Michelle Rumpel's bill limits the scope of the mandate of this kind of legislation in two ways. One, to things that are already illegal, and sort of like, or expands slightly the scope of what is considered to be legal. And second, it limits them to kids, right? So to issues around children. And third, it puts most of the responsibility in the judicial system rather than new capacities to an existing or new regulator. And I think we should have a conversation about all three of those, right? In my view, this isn't just about kids. Kids have a particular set of vulnerabilities and a limited number of rights than adults have. So we have a protection mandate to protect kids that we don't have in the same way for adults. So I think there's some value in focusing on kids, but clearly the harms that people experience on these platforms are broader than just what kids experience. I mean, that's why any country that's engaged in this process in a serious way has expanded the list of harms beyond just children.
Including Australia.
Australia, who started with kids, but very quickly moved beyond that, right? And just the idea that the judicial system is capable of handling the scale of this challenge. I mean, I'm not the non-lawyer among the three of us here, but it seems to me that there's going to be a capacity problem there, and that, again, why most countries that have engaged in this have created some body that deals with issues that don't pass a criminal threshold or a legal threshold, but do cause harm. You need a capacity for that. And either that's a regulator or an existing regulator or something like an e-tribunal that does things more quickly than the judicial system can at a lower threshold of harm or criminality. And you need one of those things. And I think this bill, their approach, if this becomes the new baseline on which we're all working, which may very well be the case. I mean, that's likely to be the case almost, I would say, then I think that's where the conversation should start, is what of those particular elements could you add to this to make it feasible?
And I'll add one more thing, which is there's a key philosophical difference too about how to protect kids between those two bills, which is also then how you imagine a regulator is involved. Bill C4 or 412, I think it's called, right? The conservative bill really focuses on parental controls and parental empowerment. And I think that there's an important conversation about those empowerment tools, but this is a whole of society problem when it comes to protection of children, and sometimes you need to protect kids from their parents. So the idea that you just hand over these tools to parents and that's going to solve all of these problems is wrong. And so these are the conversations we need to have, right? So what we're talking about here is what we should talk about at committee. These are the questions that should be asked of the government.
And another piece of that is age verification. The Rempel bill explicitly calls for a technologically mediated age verification method, which, as we all know, opens up a whole other discussion that I'm surprised they want to open, but clearly with the Senate support of the Senate bill and this, they are more willing to go down that path of mandatory age verification than the government was.
Yeah. Well, I do wonder if part of that is a potential response to backing away from Bill S210, which you're referring to in terms
To
of
keep
age
that in,
verification.
shove that piece of it in there. Yeah.
Yeah, but
Yeah.
we'll have to see. Well, it sounds like you're ready for a committee appearance on the Rempel Garner bill, if needed, or at least there's that debate. That's obviously a possibility. You know, if this doesn't pass, what else do you see? Just to close with is, else do you see as the costs of failing to get C63 enacted before an election? Obviously, it means the bill doesn't pass, and potentially we're talking about this conservative alternative. But having worked on these issues for so long, how do you situate where we are and the risks, in a sense, that we face if this doesn't get over the finish line before an election?
I mean, worst case scenario, there's a change in government, and likely this will not be a priority for that government. So it's not even that we'll be debating some version of the kid safety bill that's been presented. It's that there's nothing. So that is my fear here, and I think that that's concerning because the risks are quite enormous. This is a relatively lightly or unregulated space, and we also don't have some of the safety protections. I mean, we all know this. We've talked about this quite a bit together. But I also think that would put us so far out of line with what we're seeing globally in this area, and I think that's not good for Canadians.
Taylor?
Yeah, I think that, and there is an issue here that a large number of people across a wide range of civil society organizations and academics and citizens through the citizens' assemblies have, I think, engaged with a degree of good faith on this over 3+ years now. And at some point, there's a cost when you mobilize large swaths of society about something they care about that touches their lives in important ways, develop something that there's broad agreement on, if not complete, and then it just dies. And I think like there may be some reluctance to do that again from a lot of people. A lot of work went in from a lot of people into this, and on good faith. And on the sharper end of this, I mean, the internet might not radically change for a lot of people, but when you do look at the sharper end of some of these harms and kind of the content that the Canadian Centre for Child Protection flags every day, the 10,000 pieces of content that they flag every day that don't get taken down, like that actually has a real impact when that part of it is lost. And I hope the next government at least, and it looks like Rempel's bill signals this, at least takes the kids protection part of this seriously to get at that, right? And so I hope we are actually, even in next government, debating at least the kids piece of this a year from now.
This has been a great conversation. It highlights that there is a lot to talk about, both about this bill and potentially about other bills. And it would be ideal, frankly, regardless of where you land on this legislation, to have that before a committee in an effort to try to come up with legislation that addresses concerns on both sides, what's in the legislation, what's not in the legislation, and the broader societal impacts. So thanks so much to both of you, both for all the work that you've done over the years on this. Hopefully it's all not for naught, so to speak, and there's a chance to see some real outcome, and for taking the time to come on and discuss it here on the podcast.
Thanks for the opportunity.
Thanks.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. That's LAWBYTES @POBox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @MGeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.